campaign and a bounty. Honest to God, and you can ask Donald Rumsfeld. Donald Rumsfeld in a press conference said, "We are dropping leaflets on Afghanistan like snowflakes falling in December. And when you look at the leaflets say, you will have more money than you can dream of, you will be able to take care of your family if you provide information on suspected terrorists to the US government." So, Afghanistan is a poor country. Afghanistan is a country where there were rival warlords. And people started turning each other in. So a very large percentage of the people in Guantanamo are there because they were turned in for a bounty. And to give you an example of one, we represented a client. We ultimately got released from Guantanamo, and he went back to Afghanistan, and he found his way back to his house, and the man that had turned him in was living in his house. This is the kind of stuff that was happening. This is not a surgical strike at which we pick the worst terrorists in the world up and send them to Guantanamo. And I'll tell you how we know this, 2 ways. Number one is that there have been 778 men that have been in Guantanamo. Of those 778 men, over 500 have been released. Now, you heard me talk about how we filed the first habeas corpus petition, and we represent the men in Guantanamo, and so you would assume that the Center for Constitutional Rights and the lawyers were successful in court arguing the case and getting those men released. That is not the case. Not one of those men was released by a judge. Well, who released 500 of the 778 men in Guantanamo? The military. Why? Because the military said, after keeping them there for 2, 3, 4, 5 years, that these men have no intelligence value to us. They are not Al-Qaeda. They have no connection to terrorism, so we're going to let them go out the back door. 500 people have been let go by the U.S. government because the U.S. government knows that they had no connection to terrorism. The other reason why we know that this is so is because one of your sister schools, Seton Hall, the law school in Newark, there was a professor there that looked at the information that the government had on some of these men, the information that the government was using to justify their detention, and did an analysis. According to the government's own information, this is not something that we're making up, this is government information, 92% of the men in Guantanamo had no affiliation to terrorism, had no affiliation to Al-Qaeda. That's what the government knew. So the question then is, well, what if you guys, if the Center for Constitutional Rights aren't getting these guys out of jail, what the heck are you guys doing? And which is a really good question, and I'll tell you exactly what we're doing. January 11th, 2002, the first 20 men were brought over to Guantanamo. At the time that CCR looked at that information, and we saw two things. One, we saw that the men were being brought over, and we looked at the government's policies, and we looked at the executive orders that George Bush had listed. And one of the things that the government said was, these men are going to Guantanamo. They will not have trials. They will not have a lawyer. They will not be released until we say they can be released. They will never be able to go to court. And that they will not have any contact with the outside world because these are the worst of the worst. And so we said, well, if you're telling us that you're going to take 20 people and put them in jail under U.S. orders and under U.S. supervision, the Constitution has to apply to that. You just can't keep people in jail forever or just on your own say-so, even in a time of terrorism. So we filed the first habeas corpus petition. So what is habeas corpus? Here we go. Habeas corpus, let me tell you what it's not. Habeas corpus is not a get-out-of-jail-free card, right? So you don't, anybody watch Bugs Bunny? We have to have some Bugs Bunny fans. His thing was Daffy Duck and said, I'm going to slap him with a habeas corpuscle or something. It's not like that. You don't pull out something and you say, yes, this is a get-out-of-jail-free card. What habeas corpus is the oldest legal concept in the American experience. It actually came over from England in before 1789. It's enshrined in the beginning of the Constitution. It has its roots in the Magna Carta going back 800 years. What it is, it's that the king cannot put you or you in jail for no reason, not tell you why, because you have a right to go before an independent tribunal, which in our system is a judge, to demand that the king explain why you're being held. So all it is is a right to go to court to demand an explanation as to why you're being held. And the court will review that explanation and will determine whether you're being held legally or not. It is not a radical concept. It was a radical concept in 1789 when the King of England was doing that to to people in the United States, and it was so important to the framers of the Constitution that that not be allowed to happen. That became part of our law through the Constitution. But that's all it is. So when we filed the habeas corpus petition, we thought it was just basically just good constitutional lawyering, and it raised a very important question. We got death threats. People got death threats daily at the Center for Constitutional Rights. We approached a range of human rights organizations and said, this is going to be big. You guys have to help us with this. Nobody wanted to touch it. We couldn't get a law firm in Washington, D.C., where you have to file these cases, to walk the papers across the street into the courthouse to file them. Why? Because people were scared. I mean, this was about terrorism, man, and these were the worst people in the world. We can't be representing these horrible, horrible guys. And so in that period of time, as I said, we pulled together a whole range of habeas counsel to work on the cases with us. But we have been to the Supreme Court 3 times since 2002. And every time and 2 of the times that we've been to the Supreme Court, we've won. Supreme Court, the highest law of the land. After the Supreme Court says it is so, then all courts must do it. It becomes part of the supreme law of the land. When you go to the Supreme Court and win, you win. Here's the problem. There's this little thing called another branch of government called Congress. Every time we went to the Supreme Court and won, Congress, which was Republican Congress at the time, undid the victory. Let me tell you really quickly about what that looked like. Okay, we talked about habeas corpus. There are 2 different types of habeas corpus, or 2 different mechanisms for habeas corpus that are at play in Guantanamo. There's the statutory habeas corpus, and what statutory habeas corpus is, it's a law. It's a federal law, it's passed by Congress, it becomes a law, and you can, as a detainee or a defendant, really, look at that law and say, that law says I must be able to go before a court to do this. And there is a statute, a federal statute, 2254 and 2255. One relates to criminal detainees, one relates to immigration detainees. That statute said you get to go before a federal court. We argue, now, this is really important. The question is, of course, why Guantanamo, right? You could put these guys anywhere. Why would you put them in Guantanamo? Well, the reason why they're in Guantanamo is because Guantanamo is in Cuba, right? We have a lease with the Cuban government, which we've had since 1912, that says we get to control that part of the island. We erected a prison, we sent our military down there, we fly the American flag over the prison, but the Bush administration says, oh no, you know, that is not part of the US. So when you file a case in Guantanamo, these guys can't go, I mean, when you put people in Guantanamo, they have no right to go to federal court, because that's not part of the US. So when our first argument was this statutory right to habeas, this law says these guys get habeas. And the question the court was going to answer is, does that statute apply to people in Guantanamo? And the Supreme Court, in a landmark decision in 2004 called Rasul versus Bush, said absolutely it does. What does that mean? That means that these guys get to go to federal court. That's where we come in, right? Now, we were representing the guys. At the time, the military said, but you can't meet with them and you can't talk to them. But once we had that ruling, we said, okay, now we need to get down to Guantanamo. We were the first people to talk to any of the detainees down in Guantanamo. So we said, all right, this is a win. We can go now to federal court and now not do the get out of jail free card, but these guys can talk to the federal judges, and the federal judges can decide whether they're being held legally, and it's not just George Bush's say-so. Well, that lasted for a good 9 days, because 9 days after the decision, 2 things happened. One was that the US military came up with something that was called a combatant status review tribunal, which was a mechanism by which you don't really get to go to court, you don't have a lawyer, you don't get to present evidence, you don't get to see the evidence against you, but you get to go before a military tribunal. And the military tribunal gets to determine whether you're being held lawfully or not. Now let's think about it, right? Supreme Court says you get to go into federal court, and the Bush administration says, well, not so much federal court, but you got this military thing that we that we have here. So let's go with that. But we